guess that when the time comes, we'll announce ready if in fact we're ready, Judge.
I understand. I understand that something may come up that you think has to be done, and you may have, and that'll be a threshold issue at any such hearing as to whether it's timely or untimely. If it's close enough to trial to delay trial, otherwise, I don't anticipate having a problem working with you. Does the state have any problem with what the court's just said?
No, Your Honor.
Okay, we'll follow that then generally. When we set the trial dates, we'll go ahead and y'all need to remind me, set another motion hearing date, a date for hearings on motions in limine, and then if something crops up in y'all's opinion. What would be your next motion?
Judge, we'll go ahead and take up the closure motion at this time.
All right, you can proceed.
I'm going to move over to the podium, Judge, to save my back from leaning over.
Let me interrupt before you get started. I believe the media, two outlets have filed motions, responses to your motion. I think they want to be heard. I want to see if they're here. As Derek Ballard.
Present, Your Honor, for WXIA-TV, WGCL.
Thank you. And then I also have one from Tom Clyde.
Right. I'm Tom Clyde, Your Honor. I'm here on behalf of the Atlanta Journal-Constitution and WSB-TV and WSB Radio and Associated Press and CNN.
Well, you got them all, huh?
I can try.
All but two.
And you, the producer.
I'm Procedural. I'm with Mr. Bauer.
Perfect. All right. You have to go last. I'm sure you're used to that.
We are.
Okay.
Thank you, Your Honor.
Thank you, gentlemen. Yes, sir.
I think I'm outgunned here, Judge.
I think all of y'all are very capable people.
Thank you. I did file this motion 16, style motion to protect defendant's right to a fair trial by limited closure of courtroom for pretrial motions. I filed that last week, Judge. I did serve a copy directly to your office along with a proffer of some exhibits. In a nutshell, Judge, what we're asking for in this case is a limited closure of the courtrooms for pretrial motions where prosecution evidence is expected to be discussed or disclosed. The reason why we filed this, essentially what our concerns are in a nutshell, is because of extensive press coverage in this case and local interest, national interest, all contested evidence and argument that we would deal with as a matter of normal course in pretrial motions are going to become public domain. All that information is going to become available to any juror, any potential juror in this community or anywhere in Georgia that's got a television, internet, or smartphone. What could that include? Well, that could include any and all evidence which the court may ultimately exclude from trial, including the court could suppress evidence unlawfully seized. We have file suppression motions. The court could exclude certain evidence as more prejudicial than probative. That's an extremely common argument that we make in any case. The court could agree to redact certain statements or recordings which are preliminarily deemed admissible. That's certainly not uncommon. It could include pretrial matters that the court ultimately deems not relevant for trial. So as we work through pretrial motions, all of this is, any material, any prosecution evidence that is disclosed is going to be public domain. And it doesn't matter if the court ultimately excludes it, suppresses it, limits it, finds that it's more prejudicial than probative, redacts it, finds that it's not relevant. It's already out there. The big problem, Judge, that I see in that kind of disclosure also is that the contested evidence is going to first enter the public domain affixed to commentary, opinion, analysis from the press, from entities that, quite frankly, they're looking to sell papers, or they're looking to attract viewers. And let me say at this point, this certainly isn't my intent to bash our local papers. I take the Daily Journal, I take the Atlanta Journal. I really do that. I certainly watch CNN and other national programming. So that's not the point here, Judge. But when the prosecution evidence first comes into the public realm, affixed with that kind of opinion with it and commentary, it does have an effect on potential jurors. Excuse me. Another concern that we've got, Judge, is that the pretrial matters, evidence, prosecution evidence, which comes into the public domain through pretrial motions, are also going to be affixed to the court's rulings. Those rulings are likewise going to be reported. So what the public is going to see and hear is any and all contested evidence through these pretrial motions, and then they're going to hear about the court's rulings. And there's no way that can't stamp the imprimatur of the court onto those contested matters. This is before we ever start picking a jury. We're concerned about negative reporting. From the disclosure of evidence pre-trial out of context. Normally, a jury gets evidence at trial. And it's in context of all the other evidence. Here, if measures are not taken to curtail the disclosure of everything, this case is absolutely going to be tried in the media, in the court of public opinion before we ever attempt to strike a jury. I would submit to the court that negative reporting has effectively shifted the burden of proof already in this case. It doesn't take a lot of effort to look at the stories and articles on the internet and Facebook and through the newspaper and see that Mr. Harris has already been condemned. Certainly following a very well choreographed probable cause hearing. And if measures aren't taken to curtail the disclosure of prosecution evidence before trial, then Mr. Harris is effectively going to have to prove his innocence. And that's not how the system is set up, Judge. The burden should not be shifted by virtue of disclosure of everything before we ever get to trial. So what have you got to decide here? Well, we know that Mr. Harris has a constitutional right to a fair trial. I think, I don't want to speak for them, but I believe that even the lawyers for the press would agree with that as a starting point. Both the U.S. Supreme Court and the Georgia Supreme Court have recognized that in some instances, pretrial publicity can unconstitutionally prejudice an accused's right to a fair trial. Both of those courts have recognized closure of the courtroom in criminal cases, in particular pretrial matters, preliminary hearings, can be an appropriate and is an available remedy. Both courts. Both courts have authorized closure, Judge. And even though the press and the public may have a qualified First Amendment right under the U.S. Constitution, and under our state constitution, I want to read that directly to the court. I'm certain this is going to be addressed. Judge, under our state constitution, there's a provision, Article 1, Rights of Persons, paragraph 11, provides in part that the defendant shall have a public and speedy trial. A lot of the cases address this, Judge. But what I want you to consider is that this constitutional provision is sort of our state counterpart to the Sixth Amendment. What it's talking about is the right to a public trial, personal to the accused. Paragraph 11A. The right to a trial by jury shall remain inviolate, except that the court shall render judgment without the verdict of the jury in all civil cases where no issuable defense is filed and where a jury is not deemed demanded in writing by either party. In criminal cases, the defendant shall have a public and speedy trial by an impartial jury, and the jury shall be the judges of the law and facts. Notably, Judge, there is a provision in the state constitution, paragraph 5, that deals specifically with freedom of speech and freedom of the press guarantee. No law shall be passed to curtail or restrain the freedom of speech of the press. Every person may speak, write, and publish sentiments on all subjects, but shall be responsible for the abuse of that liberty. It certainly doesn't indicate that the press and the public have the right to be in any particular courtroom for a criminal case. I would ask that you consider that. Ultimately, Judge, the courts agree, however, that there does exist a balance between the accused's constitutional rights, right to a fair trial, and public policy, as well as qualified rights of the press and public to open courtrooms in criminal cases. Both courts, the U.S. Supreme Court and the Georgia Supreme Court, correctly conclude that such measures should be the exception, and in rare cases. And we certainly agree with that. Our position is that this is one of those rare cases. So what is the standard by which the court is going to have to make a decision. Our motion, as well as the pleadings filed by the lawyers for the press, draw attention specifically to R.W. Page Court versus Lumpkin, 249 Georgia 576. That's a 1982 decision. This is kind of the roadmap, if you will, Judge, that all the other decisions, Georgia decisions, sort of follow. And it's a pretty comprehensive case telling this court how to look at these sort of motions and how to perform that weighing of rights. The court in Lumpkin recognized that the possibility of many possible exceptions allowing closure in criminal cases, but directed that courtrooms remain open unless, and this is the significant language, Judge, the defendant or other movement is able to demonstrate on the record by clear and convincing proof that closing the hearing to the press and public is the only means by which a clear and present danger to his right to a fair trial or other asserted right can be avoided. That's it, Division 4. The court in Lumpkin directed that before closing a courtroom for pretrial hearings in criminal cases, the court is to consider the following remedial measures and utilize those measures unless such measures would not adequately protect the defendant's right to a fair trial. So what is the court asking you to consider? Well, postponing the hearing until we get a jury and they're sequestered, or change the venue, or postponing the trial, or a searching for a deer, or clear and emphatic jury instructions. The court in Lumpkin goes on to direct that the movement must demonstrate by clear and convincing proof that no other means available other than the closure of the hearing will serve to protect the right of the movement. Closure orders shall also be narrowly drawn and strictly construed in favor of open hearings, in writing, fully articulating the alternatives to closure and the reasons why such alternatives would not be adequate, and shall provide a transcription and later dissemination of those portions of the hearing which was closed. So that's kind of the standard, Judge. That's kind of the roadmap for you and how to look at this kind of a motion. We did cite some other cases in our motion that I want to call a few things to your attention. Both the U.S. Supreme Court and the Georgia Supreme Court have stated over and over that no right ranks higher than the right of the accused to a fair trial. At the end of the day, Judge, that is in fact the highest right the court has got to be concerned with. The burden of protecting the accused's right to a fair trial from the prejudicial effect of pretrial publicity falls squarely on the trial courts. So I wanted to set out for the court kind of how it is that you need to take a look at this pretrial publicity. We did submit some exhibits demonstrating some of the media coverage in this case affixed to the motion as exhibits 1 through 11. I proffer those to the court, certainly not for the truth of the matter contained therein, but basically it's just a proffer of the kind of coverage that has occurred in this case. In particular, Judge, I want to address Exhibit 1, which is some newspaper clippings from the Merida Daily Journal. And I want to again stress, I'm not here to criticize the Merida Daily Journal. That is not at all the purpose, Judge. But I do think it's important that the court take a look at some specific things that were reported and how they were reported and what effect or impact that would be expected to have on potential jurors.
Judge, just so the record is clear, we don't object to the admission of this for this limited purpose, the exhibits that he's filed with Your Honor. So just in case that comes up down the road, we don't have an objection. I don't know if the media attorneys do here.
Judge,
Wait just a minute, let's see if they have a problem with your proffer.
Certainly, Your Honor, WSIA, WGCL would object to the proffer of the various and some news media articles and clippings and website links that were submitted as attachments to the motion. It's all hearsay. I've got a couple of case sites if the court wants. I think Mr. Kilgore has conceded as much by his acknowledgement that he's not proffering them for the truth of the matters asserted therein, but that doesn't change some of the other serious deficiencies with that evidence, namely authentication as the first hurdle. And then, of course, he's got to find an exception to the hearsay rule, which we would submit can't be found here. So we would object to the proffer of evidence, certainly given the very high standard of proof that Mr. Kilgore just explained to the court is required of this.
What do you say?
it's not hearsay. I'm not offering for the truth.
The person.
Your Honor, we would join that objection, particularly with respect to what has been submitted to the court are media monitor reports about television reporting, which is actually media monitor labeled their description as a synopsis. In other words, it's not a copy of the television broadcast. It's a third party's synopsis of what they say was broadcast in connection with a television program, a television news program. Those media monitor reports have traditionally been excluded by courts in exactly this position because they aren't a copy of what was broadcast. They're somebody's synopsis of what was broadcast. And so it is that in particular is clearly hearsay. It also would violate the best evidence rule. The broadcasts themselves are routinely subject to subpoena and can be submitted to the court directly.
What would your argument be, Mr. Kilgore?
It's not hearsay. I'm not offering it for the truth, Judge. And the reality is, we could be in this courtroom for 3 months if I just simply replayed report after report after report after report. I'm offering it for whatever value the court may want to give it. It is simply, those are simply exhibits to demonstrate that the coverage has been substantial. For whatever limited purposes the court may want to give it.
I'm allowed the proffer as proffer. You could state in place your proffer. I don't see this hearsay because it's not being offered as the truth thereof. So I know the exceptions of all the media outlets that are represented in court. I know that the state has no opposition. I'm going to allow over the objection of the media outlets that are represented in court. Thank you, gentlemen. Yes, sir, you can continue.
Judge, I'm gonna proceed through these kind of quickly, but I do want to point out a couple of things from some of these articles in Exhibit 1. Thursday, June 19, 2014, this article is the front page of the Merida Daily Journal. One concern that we've got is in that article, there is an eyewitness apparently at the scene who is quoting, who's quoted saying, "It's 99% impossible to just forget your child in the car," Smith said, "not unless you meant to do it." Whether or not that is accurate recording of what the witness said, it certainly is more than a mere suggestion of guilt. And this was, of course, immediately after arrest. I'm not going to discuss the editorials, Judge. I have included some of those in here. The court can certainly take a look at those. I want to draw the court's attention to the June 24th, 2014 article in the Misleading Daily Journal. The headline being "Police Much More to the Harris Case." And therein, one of the Cobb County police spokesmen was quoted offering his personal opinion. He's certainly entitled to a personal opinion. I don't have a problem with that. But what is reported is, he says, "What I learned from my investigators shocked my conscience." And I would submit to the court that that is an example of sensationalism coming directly from the police spokesperson. The article on June 25th, 2014, again, is the headline. It's on the front page of the Misleading Daily Journal. I would submit that the headline, which reads sources, todd or death may not have been accidental, is certainly a comment on legal theories, and it's via unnamed sources. I would suggest that that's certainly sensationalized. And again, the quote from the police spokesperson is repeated in there. "What I learned from my investigators shocked my conscience." That's actually reported in a couple of stories, Judge. The case was again on the front page of the Misleading Daily Journal on Thursday, June 26th. And therein, Judge, a spokesperson, I believe this was a different spokesperson from the police department, is quoted, "There's a difference between negligence and gross negligence." He said, "The thing about negligence is it can happen to anybody. Gross negligence shows there are some other circumstances revolving around it." Obviously, that's an erroneous statement of the law, but in a comment on legal theories. But our position is, Judge, that kind of reporting obviously could have an effect on public opinion when we know from the warrant, even before the case is indicted, that negligence is going to be an issue. I want to draw the court's attention to, I think, an interesting article on June 27th, 2014. And this article, Judge, I believe is what I want you to take a look at. Because the reporting here, I think, demonstrates the impact on public opinion of potential jurors from media reports. And in this article, it's warrants, sources, law enforcement sources, and a spokesman from the police department. A couple of things I noticed in this article. There's a quote. There's a quote about halfway through the article that indicates the Cobb County Medical Examiner believes that the cause of death is consistent with hypothermia, and the investigative information suggests the manner of death is homicide, he said at a press conference Wednesday evening at police headquarters. This is Officer Bowman. he added, the designation of homicide in the medical and legal sense simply denotes a death caused by another. And Judge, I don't know where he got that information, but of course we know now with the public release of the autopsy report that statement is just not true. I've got with me today and of course, Judge, this goes to the this goes to the very information that was subject to the state's motion a couple of months ago, which was the autopsy report, which obviously now that it's public does not indicate that particular finding, and rather indicates that the manner of death could not be determined. So this is reporting on matters, Judge, that is in the public view, certainly could negatively shape opinion of potential jurors. All right. I want to call attention what my is in the 12. That's the proper, and I brought the 11 exhibits.
Judge, I think we're going to, in the media, that's fine, but if you're tendering this as an exhibit, I don't believe you have a proper witness or explanation other than this front page of the autopsy report that doesn't explain the other details of it. So I think this is kind of what he's trying to stop with this type of thing. So I would object to it at this point.
I'll offer, Judge, what I've got is the front page of the medical examiner's report. The only purpose of me proffering it at this time is to demonstrate the inaccuracy of the reporting to the contrary. Apparently, I've got a pretty high burden to prove to that judge, and so I've got this and I proffer it for whatever purpose the court deems appropriate.
Well, I think the motion brings you entitled to make progress. I think the objection can go to my consideration of it. And the gentleman from the press, do you want to be heard or not? You want to join?
We would join the state's objections.
Okay.
Yes, Your Honor.
Right. I'm allowed to number all those objections.
And
But for very limited purposes, because it certainly can come in as evidence at this point.
just for the record, Judge, Mr. Clyde was in this very courtroom arguing for the public release of that very document the last time he was here.
I think it's a little different. Y'all can't do tit for tat, no, seriously.
Okay.
But I think the point's probably taken by them.
Okay.
I'm not going there.
All right. Let me call attention to June 29, 2014. The headline there, warrant, father searched internet for child car death. That's very misleading wording. Father searched internet for child car death. Well, excuse me. We we have had a preliminary hearing where there's been testimony on this very matter. We have had the release of search warrants. And from my review of those matters, there's no indication that Mr. Harris ever told police that he, quote, searched internet for child car data. I would submit to the court that headline and what it suggests is misleading and is not supported by what has already been released, again, in the way of warrants and testimony at a probable cause hearing. This is the kind of headline and reporting, Judge, that definitely could create a false impression on potential jurors. That refrain is repeated again in the article. During an interview with Justin, he stated that he recently researched through the internet child deaths inside vehicles and what temperature it needs to be for that to occur. That's not accurate. That's very misleading. I want to call attention to July the 3rd. Okay, this was the day of the preliminary hearing. And we've got a quote from a local attorney in here, essentially a well-known local attorney affirming the charges and affirming the district attorney's decisions. If this were truly an accident, I believe I know Reynolds well enough that a consent bond would have been worked out. This lawyer was quoted as saying he had his suspicions about Harris. I've always felt like there is more to the case. And which my position would be that that certainly is prejudicial and sensational opinion. That's not the reporting of any fact at all. The day following the preliminary hearing, which would have been July the 4th, 2014, I want the court to draw attention to the court to that particular newspaper. I don't know any other way to characterize the reporting that day. It is extremely sensational. If you'll take a look at the front page, it's got an incredibly unflattering photograph of Mr. Harris with the quote, "I dreaded how he would look." Other headlines indicate possible motives, car smelled like death. It's very sensational in the way that it's put together and reported. One thing in particular that I think is very problematic and misleading in the article, the detective is quoted as follows. Stoddard said, Ross Harris returned to his car during lunch to drop off a box of light bulbs he purchased during his break. Stoddard added, surveillance video from the office's parking lot shows Harris stopped and turned back to watch as another individual walked by his car before he headed back inside for the rest of the day. That is absolutely false. It is absolutely false. This quote is suggesting that the detective had testified that Mr. Harris was walking from his car, looked over his shoulder to watch somebody else walking toward his car. That is false. And it's false for a lot of reasons. It's false, one, because it's not what's reflected on the video. But the bigger problem is that it's false because that's not what the officer testified to at the hearing. Now, in fairness to the paper, it is certainly what the testimony suggested in the way the officer testified. But it's not what he said. He did not say that he stopped to turn back to watch another individual walk by his car. And of course, our concern there, Judge, is that that leaves a false impression that is just inaccurate, and potential jurors, hear that, and their opinions are cemented. By taking measures to ensure that all contested prosecution evidence is not placed in the public domain, that's going to cure that, Judge. So that's what we're asking for. Well, I'm just going to suggest to the court, without me going through everything which I now know from the discovery, which I did not know at the probable cause hearing, is that some of the reporting in this particular article is inconsistent. I would suggest that to the court. I want to call attention to the article from the following day, which was Saturday, July 5th, 2014. The sub-headline there is Harris instructed family members on how to collect 2 life insurance policies on son. Obviously suggesting some nefarious motive, some monetary motive, when in fact that is completely misleading as to what actually occurred. What actually occurred was that after Mr. Harris was arrested, his brother and father came from Alabama and met with him at the jail, and his brother was asking questions about what about your checking account? What about the bills? What do we need to do in an attempt to help Mr. Harris's wife? And after about 30 minutes of talking and questioning, out of the blue, Mr. Harris's brother says, "Hey, what about life insurance? Do you have any life insurance?" That's how that entire issue was actually occurred. And so the way it's reported here, it gives the impression that somehow he has got a plan to instruct everybody on the outside how to get their hands on money. It's just completely inaccurate, Judge. And if those kind of things did not come in through the disclosure, pre-trial disclosure of prosecution evidence, we wouldn't have these concerns that jurors' minds are going to be affected by this kind of material. There is I want to call the court's attention to, and this goes not so much as to what came out in any particular hearing or disclosure of evidence, but just goes toward the reporting. The July 12th article indicates or discloses information reporting directly on Mr. Harris's character, which there is no way would be admissible in trial, having to do with a lie detector test he took years ago, as well as the parent admission that he once smoked marijuana in 1997 and stole a T-shirt. I think that goes to the flavor of the reporting. I want to draw the court's attention to just one particular article in the in the Atlanta Journal. And again, I'm a big fan of the Journal, Judge. I take that paper, and this isn't meant to be a critique of the paper, but I think there is one article that is extremely problematic. Following the probable cause hearing on July the 3rd, the case appeared for several days in the Atlanta paper. It was on the front page, I believe, on the 5th and the 6th. The article on the 6th is interesting in a couple of regards. One, it chronicles exactly what we're talking about here today, and that is the effect that the reporting on these, the preliminary hearing, the effect that had on the public. The public. Those same people that we are going to attempt to get a fair and impartial jury. The article states in part, it questions, is this a man who would deliberately leave his son to die in the family SUV? In the public mind, yes. Support for Harris has already turned to suspicion on Thursday with just a few words of testimony by a Cobb County police detective. Suspicion hardened into loathing. It then has some very, very sensational language after that. It indicates social media erupted with anger and calls for execution. Lock Harris in a hot car and let him die as his son did. No trial needed. I think that, quite frankly, is very accurate reporting by the Atlanta Journal as to the type of effect that the pretrial disclosure of prosecution evidence out of context can have on the public. That article is also very, very problematic for another reason, Judge, and that is incredibly sensational and I would submit intentionally exaggerated reporting, quoting from a website that in which there is no evidence or testimony from the probable cause hearing that Mr. Harris ever visited, ever. And what's being discussed is websites concerning living child-free. In part, the article says, a friend from Home Depot testified Thursday that Harris spoke of Cooper almost incessantly, so often that people were tired of hearing about him. Yet, Harris had visited an online forum devoted to discussions of living child-free, police said. Moderators subsequently took over that forum page on Reddit, private. Recent posts on another child-free site, refugees.bratfree.com, include references to Cooper's death and assertions that child deaths in hot cars referred to by some as, quote, little sizzlers, are emerging not as a series of tragic accidents, but as homicide by parents. Looks like parents will have to get more creative, says one commentator. Little sizzlers are this decade's SIDS. Not one word came out of the probable cause hearing or in the disclosure of any other evidence pretrial judge through warrants or otherwise that even suggests that Mr. Harris visited that particular site, that he was in any way involved with that site. It's clearly incredibly sensational and misleading. Why? Because it not so subtly attempts to link the assertions of that on that site, a site not linked to Mr. Harris, link it with him. The article goes on and discusses at great length the ideal or paradigm of living child-free. Part of the, quote, child-free movement on the internet, which police say Ross Harris once investigated, is quiet and rational place for non-parents to discuss their choices and why they made them. Refugees.bratfree.com has its share of rational discussion, but the site often becomes profane and angry and at best disdainful of parents. Brat-free commentators have developed their own language. Parents are breeders and paranuts. A mother is typically called a moo. A father is a duh or a duddy. Children are kids, K-Y-D-S, although infants may be referred to as loads and toddlers as toddlers. One discussion thread at Brat Free on Ross Harris is headed, duh, busted for intentional PNA by car. PNA appears to stand for postnatal abortion. Even the angriest commenters on Brat Free take pains to point out that they don't hate children and do not wish them harm, and they are outraged that Harris is being associated with the child-free movement. This article is telling the readers that even the individuals associated with this site and called child deaths, deaths in cars, little sizzlers, even they don't want anything to do with Mr. Harris. Said one, lurking parents, child-free people had nothing to do with this horrific crime. It's your kind that murder and harm children. You have kids and decide you don't want them, and expletive like this happens. Incredibly sensational and incredibly prejudicial. Something that is almost just made up whole cloth, Judge. There was no testimony linking him to that site. And of course, as it turns out, now that we've seen the discovery, there's not a whole lot there's not a whole lot out there to this this child-free suggestion. We'll deal with that at trial. I did submit the later exhibits 2 and 4, which are the online articles for the Marion Daily Journal and the Atlanta Journal. And a lot of those, Judge, are the same or similar articles that existed in the print edition, but I wanted the court, obviously, to know and to understand that those materials are available on the internet for those who don't take the print edition. Okay. All right, so what do I need to do? Can I use this? Can I use this screen? Judge, I was considering showing the court some news clips from CNN. And once I filed this motion, they mysteriously disappeared and were no longer available.
Can I ask for a 2-minute bio break while he's working with his technology?
You know. Probably will need to sit out there when you come back. Depending on where we are and what we're doing. Bio break? Sure. More part of the body first.
I don't know how to do that. Control it. How do we do it there?
Computer on screen.
Can we turn that on?
Judge, if they're really wanting to show you this, I don't think there's any need for them to actually put it up on the big screen. I think they can show it to you right here if they want to, bring it up to you, so we don't have to go through all this.
I don't have a problem with that. You want to walk over? Sure. I don't have a problem with that.
And I think we can make it where your screen can actually see it, Judge, and it doesn't have to be shown to the whole courtroom, if that's what we're really doing here.
I'm fine with that too, Judge.
I would like to do something, okay? So move along, whatever's going to be fastest, I'll do.
All right, plug that back in.
Redo.
We'll wait on that. Okay. While he's getting that together, Judge, I'm gonna submit Exhibit 13. I'm gonna prompt this. This is an article which appeared online yesterday from a essentially online blog, clearinghouse type source called examiner.com. Have you seen it, Joe?
Yeah, I have now.
Okay.
Well, I'll take a 5-minute bio break,
Sorry, Judge.
as it were.
I think we get it together.
Let's call it a 5-minute tech break, okay? I did make fun of you while you were gone. It was excessively rude.
We lost our signal.
I
It's getting no signal, so it's not coming in through the cord for some reason.
Okay, well, it says it's connected.
But I pulled it up, so it had to be connected to get pulled up to start with.
I never have to go there. This should just, it says it's connected.
It says no internet access. So you have to reboot it, try to get it going again.
I need to disconnect it.
Just click on the tab, on a new tab, click that.
Here?
Yeah. Just go to, I think,
It would never let me put in my password to hook up. It just kicked me off.
can I see it this way?
Yeah.
So none does that when it says connected but no internet access. I just have to reboot it to get it loaded up. So his-
Reboot.
The whole, just restart the computer.
Oh my gosh. Alright. I guess we could do that real quick.
I'm going to shut up that down first. Is he on his way? Thank you, Brian. When it's saying no signal, that usually means that the cord's Right? All right, so the cord's working. That's my laptop. If I just get my internet working, then that'll fix the problem.